All right, so hello, Internet. Welcome to Let's Learn Some Law with Lindsay and Felipe, who's the only one of you who actually showed up to this review session. Shame, shame, shame. But we're going to learn some law and we're going to get everybody ready for exam number 3. So, to start off, please follow along with your slides as Felipe is doing. The tutors are a secondary source. The primary authority of this class is Professor McKee's lectures and slides and the textbook. That's what you're being tested on. I'm here to help you guys, to give you something to listen to on the car ride home, but you're responsible for your own education. With that, let's get right in. What is law? I worked very hard to hold back all of the what is love jokes and the Judge Dredd jokes. 10 points to anyone who gets that reference. But the law is a body of rules of conduct established and enforced by the controlling authority of society. The government is who makes the law. We work with an adversarial system. This means that the parties to the lawsuit are opponents. You present your case in the most favorable light, and you win based on an application of the law with an impartial decision maker, usually a judge or jury, deciding the outcome. Now, what would you say are some pros or cons of this kind of system, Felipe?
Well, maybe a con is that they are winners and losers, so not oftentimes will everyone win in a case. But at the same time, it provides maybe a great opportunity for justice to be served and to resolve in the people.
Yeah, that's pretty good. In an adversarial system, as you said, there is a winner and a loser. And, if you're going through something like, say, a divorce settlement, you want there to be some meeting of the minds there. You don't necessarily want to have winner and losers. But at the same time, it allows everybody to be heard. You sort of go into this saying the plaintiff is going to present the facts as best fit their case. And then the defendant is going to present those same facts as best fit their case. And somewhere in the middle lies the truth. And that's what it's the job of the judge or jury to find. Constitutional law is one of our other things. That means the text of the Constitution is our guide, and the courts interpret that text. The U.S. Constitution is the supreme law of the land, which would be federal law. State constitutions are the supreme law of each state. Every state has a different constitution, but we all fall under the federal constitution. Now, when it comes to federal versus state, which one trumps?
Federal wins.
Yeah, federal is the overarching umbrella that all of the other states fit into, which is what makes things like marijuana laws very interesting. Here in California, we have legalized recreational marijuana. It is not legal at a federal level. And so it comes down to the states enforcing, their specific laws, and you can get a lot of tension there. Common law is sort of our legal system's great-grandparents. Common law is the body of law derived from the customs and judicial decisions of English courts. Any country that was a colony of England is likely to have common law, as opposed to Napoleonic law, which is coming out of the French court system, which is very fact-based and structure-based. In common law, you had a court of equity and a court of law. Now, court of equity was there to make you do a thing. You went there because he stole my teddy bear. You need to make him give that teddy bear back. The court of law makes you pay for stuff. He stole my teddy bear, so he needs to give me $5. Our court system has merged those into one court, so you don't have to pick, I'm suing you in the court of equity or the court of law. It's all one court now. Common law is a major source of U.S. law. You'll get all kinds of things like common law definitions. For example, the common law definition of burglary is the breaking and entering into the dwelling place of another at night with the intent to commit a felony there within. Now, that's sort of the common law. That's what people think burglary is. Now, that can be kind of tricky. You think, okay, well, if it's the middle of the day, is it still burglary? If it's not the dwelling place of another, is it still burglary? So different states can actually enact statutes which supersede that common law. Think of it as common law is your old-timey, like, that's the way we always do it, versus statute says, no, this is specifically what we have to do. Judges will base their decisions on earlier cases. Common law is where we get the concept of stare decisis, which we're about to talk about right now. Go ahead and stop me if you have any questions, by the way.
Of course, thank you.
Stare decisis means to stand by things decided, and it's a doctrine of precedent. Courts are obligated to follow earlier decisions of past or higher courts, meaning, if the Supreme Court says, hey, you have to do it this way, our state, our trial level courts have to follow that, or they're highly encouraged to follow that. Stare decisis guides the courts to be consistent, efficient, stable, and predictable. This was sort of enacted because we didn't want a bunch of higgledy-piggledy laws everywhere. We didn't want Judge Bob saying, no, I think we should do it this way, and then Judge Helen saying, no, we're going to do it this way in my court. We want everything to be equal and fair. So stare decisis, stand by things decided. You're essentially saying, hey, these guys over here thought that that's the way it is, and so we're going to go with that. Now, the difference between stare decisis and precedent. Stare decisis is the doctrine of precedent. Precedent itself is a term which means decisions that furnish the authority for deciding later cases with similar facts. So what that means is, we had a case 2 years ago in which a poodle got its butt shaved and then it bit a kid on Christmas. And now today, your poodle had its butt shaved and it bit a kid, and it was the day after Christmas. But those are really, really similar, and we decided it this way in this past case, so we're going to go with it this way now. Now, courts can't... Go ahead.
Precedent only includes cases, right? Or what else?
Well, yeah, so precedent, we're using it when we're talking about case law. Precedent is a decision by the courts. When it comes to statutes are enacted by
government.
Yeah, by your legislature, your Congress. So, it's up to them as lawmakers to say, hey, we decided to vote this way in the past, so we're going to do it this way again. Precedent and stare decisis is specifically for our legal courts. So courts can depart from precedent. If the court decides the precedent's wrong, such as, Brown v. Board of Education, when they were deciding separate but equal, they decided, hey, separate's not equal. We're going to reverse that precedent. We're not standing by it anymore. When technological or societal changes make it inappropriate to stay by that precedent, for example, there might have been a precedent of, like you can't tamper with the mail. And so an earlier court might have decided, hey, it's fine to open up a piece of mail if you just see it lying on the ground. It's not. But now with the age of email and IMs and Twitters and Snapchats and all that kind of stuff, the technology has moved so far beyond your traditional snail mail that a court hearing a case might decide we can't rely on that precedent because there's so many new facts. Speaking of new facts, it also might be a case of first impression. This means that the courts have never seen anything like it before. Now, you're going to usually get this when it comes to new technologies, like stem cell research, Bitcoin, things that, people 20, 30 years ago could never have imagined in their wildest dreams. I mean, think of it.
Right.
In the 80s, computers were like the size of this room,
Absolutely.
And now we have computers that fit in a watch.
Yeah.
So, we've gone so far leaps and bounds with technology that there's cases of first impression that come up all the time. So, cast of characters. You'll have the parties are the persons that are involved in a judicial action. The plaintiff is the person bringing the suit. I like to think of it as the plaintiff complains. The defendant is the person defending the suit, aka the defendant defends themselves. And the appellant and the appellee is what happens when you get beyond that trial stage. Plaintiff and defendant, trial. And then the appellant is the person who appeals whatever trial decision was made. So say plaintiff, defendant, the plaintiff won, yay, the defendant's like, that sucks. And so they are appealing that to the next level. They become the appellant. And the person who is against whom the appeal is filed is the appellee. So it becomes very tricky and very important to spot that when you're reading over appellate level, or so your appellate courts, your Supreme Court decisions, because the defendant can be the appellant or the appellee. The plaintiff can be the appellant or the appellee. In trial courts, the plaintiff is the one who's bringing the suit. That's always the way it is. But when you get to that next level, you have to really focus on who are we talking about here. And the judge is the impartial person overseeing the trial. They can also be known as justices. On our Supreme Court, we have our Supreme Court justices versus, trial courts, we have judges. I've always heard it said that when in doubt, call them a justice. No one who is at justice level ever wants to be called judge, and anyone who is a judge always wants to be called justice. So when in doubt, always promote. So standing to sue. What this means is you need sufficient stake in the controversy to justify the lawsuit, aka you have to have a reason to bring this before the court. This can include injury or threat of injury. It's required to bring a suit. So you can't just show up to court and be like, I heard a dude got shot in Norway yesterday and I'm going to sue on his behalf. You don't know this person. You cannot pronounce his name. You have never been to Norway. You have no standing to sue. You can, however, sue on behalf of others. Think about things like class action lawsuits or a parent suing on behalf of a minor. Minors don't have standing to sue, so they always have to have someone sue on their behalf.
Or if I were a third party intended beneficiary.
Yeah.
Contract.
Yeah, with contract law. Good old contract law. You can sue on behalf of others, but even then you have to have standing to do so.
Right.
I'm suing on behalf of this person because of X reason, like they're related to me, or I'm their beneficiary, or what have you. Jurisdiction. Jurisdiction's always fun. This is the authority of the court to hear and decide a specific case. Courts have to have jurisdiction before they can even hear the case. Basically, courts need to have the right to be like, what's up? I'm going to make decisions for you. There's a bunch of different types of jurisdiction, which we are going to go over in, for you, probably agonizing detail. It's a little late. This includes in personam, in rem, subject matter, original, appellate, exclusive, and concurrent jurisdiction. So let's jump right in. In personam jurisdiction, which stands for power over the person, think person, personam, they're kind of linked. This is also known as personal jurisdiction. So what this means is courts have jurisdiction over residents of certain geographical areas. California courts have jurisdiction over California incidents. Los Angeles courts have jurisdiction over things that happen in Los Angeles as opposed to San Bernardino or San Diego courts. Now, we also have what's called the long arm statute. This happens when courts obtain jurisdiction over non-residents if they have had minimum contact with the state. AKA, let's say I'm from California and you're from Nevada. And, I'm driving along and woo, Vegas! And I'm driving through and I rear end you. And then I'm like, peace out, homie. And then I bounce back to California. Via a long arm statute, you have the ability to say, hey, no, I'm going to reach over and I'm going to grab you and drag you back to Nevada because you came into Nevada, you were partying, you were here for a certain amount of time, you caused a ruckus, that was minimum contact. I need you to come back here so we can answer this lawsuit. So long arm statutes are very fun. It's a good way to essentially yoink someone out of another state and back here so that you can go through with your lawsuit.
And that only works in the United States, not abroad, right?
I mean,
we can't like yank someone from Canada or Mexico, right?
I assume that the answer to that is going to be found in whatever treaties we have with other countries.
Right.
Because there are certain countries that do have
that would help out,
yeah, they aren't gonna
back.
they aren't gonna release people back into custody. That's gonna be like a international law question, and we are not there.
Not there, huh?
If you want to know the answer to that, please go to law school or do some research. In rem jurisdiction, aka power over the thing. I don't have any fun ways to remember that. I just always remember, yes, more people. Maybe. I hope. I always just remember in rem as like the band REM is a thing. So I remember power over the thing. Like whatever fun little tricks you can get to get this stuff up in your brain is always good. Hello. So this means jurisdiction over property located in the boundaries of the state. AKA California has interim jurisdiction over properties in California. Now this can be even if the people in the lawsuit are not from the state. So let's say I'm from Georgia and you're from New York. And we rent a townhouse in Los Angeles because we want to be fancy people. And we get into a lawsuit. California would have interim jurisdiction because the property in question, the townhouse in Los Angeles, exists in California. So even though we are not from California, we can have to come back here to deal with the issue at hand.
But that's only if it's over a thing. Like, what if the case involves two people?
Yeah, well, so in rem is specifically power over a thing, aka like property that's located within the boundaries of the state.
Got it.
So like if it was a child custody dispute or something, that wouldn't necessarily be the same thing. That's a whole other family law thing.
Okay.
In rem is specifically for, properties, locations, those kind of things. Subject matter jurisdiction is, again, so many different types of jurisdiction, and it is very important to know which one you have in this case so you know where you're suing someone, essentially. This is, certain cases are heard by specific courts, and you are limited on the types. For example, bankruptcy court is the only one that hears bankruptcy cases. The IRS courts are going to hear IRS issues. This is, we only deal, think of it as, Walmart versus a yarn store. You can probably find yarn in Walmart, but a yarn store is just dealing with yarn. Subject matter jurisdiction is we are specifically for this, and so we call dibs. Jurisdiction essentially is a way for the court to call dibs. Original jurisdiction is the power of the court to take, try, and decide a case, aka who hears the court first. Who hears the case first, excuse me. Hence why it is original. It is first. It's usually going to be the trial courts. If you guys remember your court system diagram, the trial courts are sort of our beginner's level. They're the bottom of the pyramid. And with original jurisdiction in the trial courts, they're hearing questions of fact. They're hearing, this is what this witness said. This is the speed limit you were going. This is the type of dog that bit you. This is where you're presenting evidence. This is where you're arguing your case. Appellate jurisdiction is that next bump up. This is the power of court to hear and decide an appeal. The appellate's courts act as a reviewing court, and so they deal with questions of law. You're not going to get to the appeals court and say, oh, I just found this eyewitness over here saw the whole car crash. They're going to say, okay, bump it back down to trial courts. The appellate courts hear, the judge didn't allow me to present this evidence that would have exonerated me, or the other side tampered with the jury, and so I didn't get a fair trial. It's going to be questions of how was the law handled and whether there were any issues there. So again, if you come up with new evidence, that's when you go to the appeals and say, hey, we need to bump this back down to the trial level because I have new evidence that wasn't able to be heard. Exclusive jurisdiction is where a case can only be heard in a particular court. This sort of goes along with subject matter jurisdiction. Exclusive federal jurisdiction is federal crimes, bankruptcy, patent law, trademarks, copyrights, and suits against the U.S. So if it's going to be Jones versus the United States. Exclusive state jurisdiction is everything that's not federal or concurrent, such as family law, auto accidents, speeding tickets, those kind of things that are specific to each state and how that state sort of runs its show. Concurrent jurisdiction is where two different courts have the power to hear a case. Now, this is federal questions and diversity of citizenship. Do you guys remember what diversity of citizenship requires?
Two people or two parties from different states.
Yeah. What else? It's a twofer.
And it's a federal crime. I'm not sure about the second one.
Diversity of citizenship, which we'll get into in I think a couple slides, is citizens of two different states, and the issue has to be over $75,000. So if it's $74,999.99, it doesn't count. And this is because, these are big pocket issues.
What if it's exactly 75,000?
I want to say if it's exactly 75,000, it counts. I believe it's 75 and over. That would be a good question to ask your professor before the test. Because you will not see her on Monday. Or you may. I don't know what your lives are, but I'm pretty sure you won't.
Okay.
Federal questions are U.S. Constitution, Congress, treaties. These are things that really are affecting our nation as a whole, not just individual states. And in this case, it applies federal law. Yeah.
Immigration are more of a federal issue or a state?
I would argue it's a federal issue because, immigration policy as a whole is controlled by the U.S. government, but it can very well be a state issue. Again, also a good question to ask your professor on Wednesday. But I want to say my gut says federal, but I am not an authority on immigration and also not a lawyer. You guys are going to have to practice saying that because you're going to have to say it all the time. Diversity of citizenship, so this is what we were just talking about, is citizens of different states over $75,000, so that probably answers your question, and you apply the state law. So this is essentially, going back to our earlier example, if I'm from Georgia and you're from New York and we're arguing over a condo in Los Angeles and it's $100,000 condo because it's super fancy and it's got gold toilets and a view of the center of Los Angeles and it's amazing, and we're arguing over oh no, I want to sell it, and you're like, no, I want to keep it. That becomes a diversity of citizenship, because then it's okay, do we go with New York law, do we go with Georgia law, do we go with California law? And so then you are able to get those, well, do I want to take it federal, that kind of thing. So that two people over 75 is your big ticket items for diversity of citizenship. Now, venue. I know there can be some confusion between venue and jurisdiction. Jurisdiction is the power of the courts to hear something. As I said, it's the courts calling dibs on, I want to see this case play out. I want to make a decision on it. Venue is the geographic district in which the action is tried and the jury is selected. So this is the physical location. Are we gonna have it heard in the courthouse downtown? Is it gonna be heard in San Diego? Is it gonna be heard in Riverside? You need to choose the most appropriate location for the trial. If you youngins can remember, with the O.J. Simpson trial, they requested a change of venue because they were like, he's not going to get a fair trial where you want to have it heard. We need a different area where he's not going to have a biased jury of his peers. So you can request a change of venue if you feel you won't get a fair trial. You're not guaranteed to get that change of venue, but you can request it. And, I imagine if you're like, hey, I don't think this is fair, they're going to err on the side of caution and give you some place where you think you can get it fair. So, another example, Timothy Bay, the Oklahoma City bomber, he requested a change of venue saying, like, there's no way I can get a fair trial, in Oklahoma City for obvious reasons. So again, jurisdiction versus venue. Jurisdiction is, can we even listen to you? Versus venue is, where is this trial going down? Jurisdiction is the, why do we care? Venue is, where do we want to have dinner? ADR, aka Alternative Dispute Resolution. It is quite a mouthful, but it is very useful. Now, why is someone going to want to go through ADR? Well, court trials are hard to get. You can look anywhere, if you're lucky and it's amazing and a real speedy, you might go to court in 2 years. It can be anywhere as 5 or 6. It can really drag on, and, that gets expensive. Trials cost time and money. You're having to pay for your lawyers to do all the work, all the research, get your exhibits together. Then you're having to pay to go through trial. You're paying for all the trial costs. And it's easier to bargain with the other side when it's just you and me and a mediator sitting down and hashing things out. You might not want to get a lawyer involved when you're like, look, we just need somebody to help us settle this. This also keeps the courts moving. If we don't have 18 different trials going on of like he said, she said, and rah, Capulets versus Montagues, bickering family feuds, we get it into ADR, they hash it out, they settle out of court, and we can start hearing some other stuff that can't be easily settled via mediation. Now, the opinions of the court. Everybody has them, judges like to give them, and so we're going to go over them. It's important, especially when you're looking over briefs. You need to know whether it was a unanimous opinion, a majority opinion, whether there's anyone who dissents. So we're going to break down the sort of 5 basic opinion types, which are unanimous, majority, plurality, concurrence, and dissent. Okay, unanimous opinion. Everyone agrees. I hope I don't have to explain that in great detail. It's the most straightforward one you're going to have on your test. Do you guys remember how many justices are on each court?
379 or 359.
Pretty good.
Right.
I'm blanking on like, oh my god, is it 7 or 9 for this, or 5 or 7 for the state courts? We'll find out because we're going to go over the court system diagram at the end. But this is all of your justices agree, we're good to go. Now, a majority opinion is a judgment that gets more than half of the votes. So 5-4, 7-2, what have you. As long as there's, even +1, that's a majority opinion. Now, when you're reading briefs and decisions, the majority opinion is going to be written by a judge who holds it. Judges explain why they've decided yes or no or maybe or send it back or what have you. So a majority opinion is this sort of overarching, this is how we've ruled, and then a justice will come along and say, hey, this is why we decided this. It states the outcome of the case and the reasoning. Judges don't just get to be like, because we said so. As with everything, they have to show proof. They have to show this is why we think so. This is the precedents we're going on. This is the statutes we're going on. This is how it was reasoned, and this is what we heard and we accepted. Now, a plurality opinion can be very rare. It's where no one decision has over half the votes. So the deciding opinion is the highest number. So it might be like a 4, a 3, and a 2, where there's no, there's a bunch of stuff that's split up. One side says, yes, do this. The other side says, no, reverse it. And the third one might say, hey, maybe we should just send it back to the trial courts. So essentially, whoever is the winner, whoever is deciding the outcome of the case, is just sort of whoever makes it to the finish line first. Whoever has the highest number out of all of the different numbers. Now, concurring opinion is where a judge agrees with the outcome, but not the reasoning, and then decides to tell us why. So it might be, I agree, we should affirm this decision, but not because that dude's dog clearly bit the other dude, but because the law says dogs can only have 3 teeth and this dog had 2 teeth, so it can't actually bite someone. It's a, I agree with this outcome, but not why. And again, justices like to give their opinions. So, you can get people being like, hey, I don't quite agree with how you guys said this. And that can be really interesting, especially if you're looking for precedent. If the majority of opinion says X, and then this judge sort of agrees with them, but says, hey, this also applies to these other scenarios, and you're in one of those other scenarios, you get to be like, hey, this dude said it was cool. In a much more formal way, of course. Now, dissenting opinions are what you always want to watch out for. This is where one or more judges disagree with the ruling. They think the outcome and the reasoning are bad, and they want to tell you about it. Now, dissenting opinions don't affect the outcome of the case. Whatever the outcome is, the majority opinion, the plurality, concurring, what have you, they've decided, yes, no, maybe, this is the result. Essentially, dissenting opinions are where some of the judges are like, I don't like it, I don't want to be on the side of history that says that was okay, and I'm going to complain over here. So it's really useful for persuasive arguments. Say you have a bunch of statutes and cases lined up, and you're like, oh, and by the way, they also had this dissenting opinion where they clearly spell out my whole point. It's sort of, it can be a cherry on top, but if the other side has statute and hard fact, and you're just using a dissenting opinion, dissenting opinions aren't law, aren't precedent. They're not really an authority. They're just sort of an extra, oomph. You can cite a dissenting opinion if you are using it as part of your persuasive argument, but you have to make clear it is a dissenting opinion. You don't get to be like, well, Justice Ginsburg said this the other day, and then it was a dissenting opinion, and it has no sort of influence on precedent or the law. So, as with anything, you have to be upfront. You can't sort of play fast and loose. You need to make sure you're clearly saying what is an opinion, what is a dissenting opinion. All right, so with that, we're in the home stretch. We are going to now go over the court system diagram. As I told you, my method for studying this was I printed out about 30 blank court system diagrams, and I just went through and filled them out one after the other until I had it in my head. So with that, we are, I forget which order they pop up. Okay, so what we're going to do now, since I now have 2 of you, thank you so much, I'm going to go ahead and say, we'll start here. What area is this at the bottom? What level of court?
The federal
Well, I mean, like this whole underneath the dotted line, this whole chunk down here. What is that?
regional trial courts.
Yeah, very good. And then what is everything above it?
Appeals and Supreme Court.
Yeah, it's the appellate level, which includes courts of appeals and Supreme Court. So, original jurisdiction. Remember, at the trial courts, that's where the court first hears the case. Everything above that dotted line is you're appealing it. Okay, trial court. What goes in the rest of the trial court box? So when you guys get this, you will literally be presented with a blank document, and you need to be able to fill all of this out. Including things like what goes in here, what goes up here. Like, Or,
How many points
You know.
is this worth?
20%.
20 points? 20% of her?
it is worth however much your professor has told you it is worth.
Okay.
Dodge.
20 points.
It's not something you want to sneeze off. It's also really important for you guys to know this court system diagram. You guys need to know how the courts work. You need to know, okay, I'm here. I need to get to this point over here. How do I do it? You don't want to be like fresh graduated from Mount Sac in the law office and your boss is like, oh, I need an appeals brief. And you're like, that's for the trial courts, right? They're going to be like, get out, you're fired forever. Like, you don't want to be that guy who's like, oh yeah, all those 3 justices of the U.S. Supreme Court, Bob, Jones, and Rick, they're cool. You guys are going into this profession, so you need to know what to talk about, essentially. You need to know where you're going. And, this is the foundation of the rest of you guys' classes. When you're doing legal analysis, when you're doing civil procedure, when you get into torts and contracts, it all builds on sort of an understanding of our court system because, that's the career we're going into. We are entering into the court system. We are becoming one with the law. And so we need to know what's up with it. So trial court is unlimited, limited, and small claims. It has, exclusive state jurisdiction. Do you guys remember what's exclusive state jurisdiction? Yeah. Basically everything that you don't write anywhere else. Family, auto, etc. Okay, U.S. District Court. Do you guys remember what goes in these 2 right here?
Wait, where?
These 2?
On the right of U.S. District Court?
Yeah.
IRS and bankruptcy.
Yep. IRS, BK. Like,
Burger King.
Yeah. You will have to write these in. You'll have to write in things like or writ of certiorari or what have you. So, like, these are tiny ones that, like, if you guys miss this giant or in the center, I will personally come up and cry at all of you watching. Take the small points where you can. So, U.S. District Court has exclusive federal jurisdiction. Do you guys remember what goes in the rest of that box? I know it can be hard to be like, let me rattle it off, but IRS, bankruptcy, admiralty, federal crimes, trademark, copyrights, patents, etc. I found when I was studying for it, I sort of like a weird tune, I would go IRS, BK, ADMR, Fed C, trademark, copyrights, patents, etc. Like, I just had like a stupid rhyme that got stuck in my head, and that's how I remembered it. Sometimes you have to trick your brain into remembering stuff. But bet your boots, I remember federal crimes, trademarks, copyrights, and patents are exclusive federal jurisdiction now.
Maybe also if we remember the number of how many words we need to put in there.
Hey, so whatever works.
1, 2, 3, 4. Oh, that's 3, 5, 6, 7, 8. So there are 8 things, then etc.
So yeah, again, like, whatever you guys can come up, if you guys are studying together, whatever you can do to get this into your brains before your test. Because, you need to know this stuff, and 2, it's a lot easier to just be like, yes, I memorized placement, scribble, 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 than being like, oh shoot, what was jurisdiction again? This is just straight memorization. So, concurrent jurisdiction. Do we remember what goes under there?
Federal state issue.
Yeah. Federal questions, including U.S. Constitution or U.S. laws, and diversity of citizenship. Now, do you remember the 2 for diversity of citizenship?
Over 75K and people in different states.
Exactly. Citizens of different states, over 75,000. All right, again, easy one. Death penalty. In California, if you are at a death penalty case, you get an automatic appeal to the Supreme Court. Anything else, you have to petition for it. So with that, we have concluded the original jurisdiction trial court level on the state and federal sides. Pop quiz. Which of these sides is state and which of these sides is federal?
Left side, the trial court will decide state, and the right side, the U.S. District Court will decide federal.
Very good.
Wait, and then the middle, concurrent jurisdiction.
Yeah.
That's kind of more federal, huh?
Concurrent jurisdiction, so federal questions, diversity of citizenship, you'll notice it says or. If you have concurrent jurisdiction, you get to sort of like swippy swappy decide which one is going to go the best for you.
Yep.
All right. Appellate jurisdiction. What two courts are in the appellate jurisdiction?
State appeals court, federal appeals court,
Yeah. What else?
Supreme Courts.
There you go. The appellate level includes our appellate courts at the state and federal level and our Supreme Courts. It's important to remember that Supreme Courts are an appellate court as opposed to a trial court. They're not hearing your cases for the first time. They're hearing it and then they're deciding it based on that application of the law and whether like any shenanigans happened. Okay, California Court of Appeals. What goes in that box? It's okay, you guys still have time to study. You have a fun, long weekend. The California Court of Appeals is 6 districts. LA is in the 2nd district. I always remember it as LA. We're not the best, we're number 2. You know, LA is perfectly fine. I'm an Inland Empire gal myself, but...
How do you remember 6 districts?
Because California looks like a 6. California's a 6.
Yeah.
Again, it's simple, ridiculous ways, but they work and they help you pass tests.
I don't think we'll forget it now.
There you go.
I will.
All right, California Supreme Court. What goes in there?
All right, 7. It's 7 justices.
Yep. See, you were right. That was a test if you passed. 7 justices appointed by the governor for 12-year terms and reapproved by voters after that. Why didn't I just click? There we go. So again, you know, I also remember California, the L in California looks like a 7. There you go. Or you can also remember 6 and 7. Why was 6 afraid of 7? Because California has crazy laws. So with that, U.S. Court of Appeals, what goes in there? I'll make it easy on you guys. We have 13 circuits. You can also remember that as the 13 original colonies. California is the 9th Circuit. We're also affectionately or not so affectionately, depending on who you're talking to, referred to as the 9th Circus because we are a very, very liberal circuit and we like to bring up a lot of laws and court cases. All right, writ of certiorari. What goes in there?
How do you remember California as the 9th Circuit?
I've always heard it referred to as the 9th Circus, so I just get it together.
Isn't there like a horror movie, District 9 or...
There you go.
Oh.
Right.
See, again, literally, like any of these like fun little connections you can make in your brain, you know, it might sound ridiculous and you might be like, why is this working? But you get there and you sit down and you see the test and you're like, oh, District 9, 9th Circuit. Ding, I got that question right. Thanks, Felipe. So, you know, whatever works. Don't be ashamed or too proud to think of whatever ridiculous way will help you pass the test. Okay, writ of certiorari. What goes in there? 4 out of 9. So the writ of certiorari is the rule of 4. That means 4 out of the 9 Supreme Court justices have to agree to hear your case. With the Supreme Court, unlike our California death penalty goes straight to the California Supreme Court, the U.S. Supreme Court, they are not guaranteed to hear them. If they decide, nope, we don't want to hear you, like, good luck. They didn't want to hear you. Sad for you. But if 4 out of the 9 say, hey, I think this has merit, I want to hear this argued, it goes on to their docket. All right, remember, federal questions can take you from the California Supreme Court to obtaining that writ of certiorari. Because the U.S. Supreme Court, they want to hear cases that are going to affect the nation, that are egregious or, really interesting. They're going to answer a bunch of precedential questions. They're going to set precedents. They want to hear these really big, impactful cases. All right. Their 2001 record is 81 out of 8,000 cases that came before them. So it's a long shot getting your case before the U.S. Supreme Court. They are essentially the keepers of our law. They are our top court. And so they have a lot of stuff that they have to get through, but they also take time and really reason things out, we hope. And really try and do their jobs the best that they can. All right. Speaking of U.S. Supreme Court, what goes in that box?
Appointed by president.
Yeah. You have 9 justices. It is a lifetime term. They are appointed by the president.
Oh.
And that's it, apparently. So we have reached the end. Thank you two, for showing up. Shame, shame, shame for the rest of you who couldn't make it down to this lovely Turk. That has been Learn the Law with Lindsay. And now, my 2 awesome intro students. Again, reminder to everybody, this has been a fun and helpful review session to sort of stir your brain and get you studying and finding out your own way. If I have said anything that you feel is incorrect, if you have any questions about, well, Professor McKee said it this way, but she said it this way, go with Professor McKee. You guys are being graded by her. You're being tested on her material and the book and her lectures. She is your primary source. I am a secondary source, and I'm not even like a Witkin. I'm like a legal encyclopedia. You do not want to cite me. So with that, good luck, everybody, and enjoy your holiday.